Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we are going to talk about GEICO covering $5.2 million settlement because a person got an STD in a vehicle. If you find this video interesting or helpful, please subscribe to the channel, like the video, hit the notification bell so you can keep up with all that's going on. So let's just jump right into this case because this is an odd one. I pulled the opinion off of the website from the Missouri Court of Appeals of the Western District of Missouri. And so in this particular case, what happened is this lady with the initials of MO gets into a vehicle with someone that she's in a relationship with, and they engage in sexual intercourse. According to her, she entered into this sexual relationship without knowledge that this person had an STD. And so he did not disclose any STDs. He didn't disclose any problems that could be had in their sexual relationship, even though he knew that he had an STD, according to her. And so they engage in intercourse, and she ends up contracting HPV from him, which is sexually transmitted disease. So she discovers that she has this STD as a result of this sexual intercourse in an automobile that was owned or operated by the person she was having a relationship with. And she discovers that he is covered by a policy of insurance for injuries due to negligence through GEICO. GEICO is his insurance company. So she sends an offer to settle the case to GEICO for $1 million. Essentially giving notice that there's a claim, that she makes a claim, and she makes an offer to settle for $1 million. And they deny it. And at the same time, GEICO files a hearing in the federal court seeking a declaratory judgment as to the rights and responsibilities that they would have for coverage. Well, while that case is pending, MO enters into an arbitration agreement with her lover. And they have a full-blown hearing in front of an arbitrator where they present evidence, cross-examination, and all those things. And the arbitrator finds that the insured, the person she was having sex with in the car, had knowledge of the STD, did not disclose it, and therefore he was negligent in causing her to have the STD. And as a proximate cause of that transmission, she suffered damages, including future medicals and past medicals and all of that stuff, as well as, pain and suffering, mental anguish, and all that stuff. So the arbitrator finds in favor of MO and awards an arbitration award of $5.2 million. Well, MO files a petition to the trial court to affirm the arbitration agreement and sends a copy of that notice to GEICO. Well, GEICO files a motion to intervene in the trial court and seeks to overturn the arbitration agreement, saying they did not have an opportunity to litigate, they didn't have an opportunity to do discovery, and as a result, their constitutional and statutory rights were violated, and they should not be responsible for paying the amount. Well, the trial court affirms the arbitration agreement and also grants the motion of GEICO to intervene, but denies their requests to overturn the arbitration agreement, essentially saying that GEICO is responsible for paying the $5.2 million when they could have just paid her $1 million a long time ago. Well, nevertheless, they file an appeal to the Missouri Court of Appeals, and Missouri Court of Appeals affirms the decision of the trial court affirming the arbitration agreement, holding GEICO liable to pay the $5.2 million unless there's some, the news articles don't tell what happened with the federal hearing, so I'm trying to figure out what's going on with that. But the bottom line is that because this was an injury that occurred through the negligence of a person in an automobile that was covered by an automobile liability policy, GEICO is being held liable to cover the STD as a result of the sexual intercourse that occurred in the car. Now, if the insurance provisions made that an exclusion within the policy, then it would be possible that GEICO might not be responsible for that. My guess is that if all of this would not have taken place had there been a specific exclusion in the policy for injuries resulting from sexual intercourse because it was not part of the normal operation of the vehicle. But there's no telling what that information is, because when things are done in arbitration, all of the stuff that's available in a trial is not necessarily available to the public. That's one of the benefits of arbitration, is that it's private. It's not something that everybody gets to see, whereas a trial is something that's public, is public information. So that's the benefit of arbitration, is that you can keep some of that stuff in the dark, whereas everything in trial is for the public out in the light to see. So anyway, I thought that was an interesting case showing that an insurance company has to cover $5.2 million award from an arbitrator because of a sexual transmitted disease that occurred through the transmission of a motor vehicle sexual intercourse. So I hope you found this video at least entertaining and educational and helpful. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.